Let's talk a little bit about the David Hearn case. David Hearn was a former Olympian. He was charged by the U.S. Attorney for the District of Columbia with vandalizing the reflecting pool that is in Washington. The pool was recently refurbished, repainted, recoated. The new coating did not last when the water was put in the pool. For some reason, the coating peeled up. Some of the officials of the current administration accused Democratic protesters of cutting it with a knife or a razor blade. There is apparently a huge cut in the reflecting pool in the paint job. Once they put the water back in, the whole thing fell apart. Mr. Hearn was indicted for essentially a criminal damage to property case. And then 6 weeks later, the U.S. Attorney for the District of Columbia, Jeanine Pirro, a former host on Fox News, dropped the prosecution. There are a lot of people who criticize Fox News, criticize Ms. Pirro, but it is very clear that she did the right thing. Rule 3.8 requires a prosecutor to, quote, refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. So that pretty much would defeat the case, because Mr. Hearn, there's just no evidence that he used any type of device to cut the paint on the bottom of the reflecting pool. The pool is not very deep, it's just a couple feet deep. And Mr. Hearn looked at the coating and apparently touched some of the peeled paint. He was then charged with, and the argument was that he was responsible for it. It just isn't true. There's evidence plenty of videotaped evidence from lots of people that the paint had peeled up long before he arrived to look at the pool that day. And I think it's something any normal person would do, is go up and say, what in heaven's name has happened here? How did this go on? How did we end up with a reflecting pool that the repair job completely failed? In any event, Rule 3.8 requires the prosecutor to disclose evidence, exculpatory evidence to the defense, and it also required her to drop this case. And even after conviction, a prosecutor has a duty. Subpart H, when a prosecutor knows of clear and convincing evidence establishing that a defendant in the prosecutor's jurisdiction was convicted of an offense that the defendant did not commit, the prosecutor shall seek to remedy the conviction. There just is no basis for this prosecution. Ms. Pirro acted appropriately and ethically in dropping that prosecution and walking away from it. She will take a lot of flack and abuse, but she did the right thing. She met her ethical duties. Oftentimes, the job of a lawyer is to give bad news to a client, and the bad news here had to go to the top of the Justice Department. They don't have a case against Hearn. He didn't do anything wrong. There's no evidence he did this. So credit where credit is due to a lawyer who appropriately dropped a prosecution when it was clear that it was not a real, valid, bona fide, meritorious prosecution.